Hi, I'm Marcus Vaden of Marcus Vaden Law. I just had to stop and get me a glass of iced tea from Come and Go. Unsweet peach is my flavor of choice. I love it, and they have the chewable ice, which you got to be careful about because at least I have a bad habit if I'm not careful of chewing the ice, and it makes my teeth hurt sometimes when I chew it too much. So I got to be careful about that. I wanted to talk to you a little bit about a legal issue. It's not a legal issue. It's a legal procedure. It's called mediation. And if you think of mediation and you've never been through it, think of, negotiations, settlement talks, that type of thing. Mediation, I went through one yesterday. A couple of other attorney friends of mine, we were handling a case together, and it was against a psychiatric hospital that had done some really bad things to somebody, and they've got a number of other plaintiffs, but our plaintiff was able to settle. We were able to get a settlement of about $600,000, and we were happy with it. Our client was happy with it. Under the circumstances, I thought it turned out well. But the mediation, what mediation is a formal, structured procedure to where parties, and you can do it with more than one party. It doesn't have to be just a plaintiff and defendant. You could do it. I've done it with a number of plaintiffs, one defendant. I've done it with a number of defendants and one plaintiff. And you could do it a number of ways. But basically, you go to a location. Sometimes I've even done it by Zoom. I think it works a little better in person. Just when everybody's there in person, it kind of shows a little bit more that people are paying attention. They're working on it a little more earnestly. They're thinking. They're talking about it. And there is a mediator. Usually it's a licensed attorney in the state, and at least in Arkansas, they're also certified by the state Supreme Court. But you go to a location, and the plaintiff or plaintiffs will divide up in one or more rooms, and then you'll have defendants do the same thing. And the mediator, but all the parties will have sent them some information, written information that they can review and kind of know about the case and know what the facts are, know what the defenses are. And so the mediator will start usually with the plaintiffs and kind of talk to them about their cases. And then he'll go to the other side, and usually in that first time, the plaintiffs will start off with a demand of settlement. A demand meaning how much they will settle for. And usually tied. They don't start off with their bottom line. And then the defendants, after they talk with the mediator will come back and he will deliver the defendant's counter to what the plaintiffs initially said. And they do this back and forth all day long, and the mediator will go and talk to the plaintiff and plaintiff's attorneys about the strengths and the weaknesses of their case. And he will talk to the defendants about the strengths and weaknesses of their case. And he or she will play devil's advocate with both sides, because the mediator does not make a decision. They are there to provide a structured way to talk negotiations. And I got to tell you, it's very effective. Even if you don't settle a case, you learn things about the other side's case that you probably wouldn't know, that can assist you at trial. You kind of understand more about what their arguments are, more of the things that they think are important in the case, and how they feel about your case. I've had cases before where I could tell by the responses to the other side, they just didn't really value the strength of my case. And a couple of times I've actually had a mediator come and say, look, they don't think you got a strong case. They don't think you got a strong case on damages. Don't think you got a strong case on liability. And they're just not willing to pay much. And so then my client and I have a decision to make. Are we going to go ahead and take it and realize, hey, our case may not be that strong? Or are we going to go ahead and go to trial? A lot of times we go ahead and go to trial, and if the offer's just too low, and see what a jury will do. And so far, that's worked out pretty well. But anyway, if you ever have a case, if you've got a case going, or you have the opportunity to mediate, I am always, doesn't matter if it's a divorce case, I don't do divorces, but, or if it's a personal injury case, it's a land dispute case, it always is a good idea to mediate. I have mediated all of those types of cases I just named, and done so with a lot of success. It's just a good way to settle disputes. It saves you from having to, a lot of times, to go to trial. Now, trial, sometimes there are cases that you have to take to trial because of the facts of the case, because the defendant's not being reasonable, or it may be, I have had clients sometimes that just, look, I want to have my day in court, and I want to tell my side, and so we've done that a couple times. One time I can remember, only one that I can really remember much, but my client had me do it go ahead and handle the case. We could have gotten a better result than we did in trial, and I warned him that I was afraid that with the facts, that this was going to be a problem for us, and it turned out that it was. If you get a chance to do the mediation, I strongly recommend you do it. Trials are grueling. Now, it's what I do, and I love doing trials, but it's my job. The case is not my case. And so I'm not the person that's lost anything. I'm not the person that has been victimized. And so that is something that is makes a big difference when you are not the party. You're just the attorney. There's still an emotional aspect with the attorney, but it's not exactly certainly not the same. But a trial oftentimes is grueling, and particularly a jury trial, just because, depending on the subject matter, you're going in there in a situation that you're not used to being in. You're going in there where you're having to get up and sit and testify about things that can be very private. Particularly, let's say you're a victim of a sexual assault. You're a victim of a domestic assault, and you are suing a defendant or defendants. Those things are very difficult to go and talk about in front of 12 people that you don't even know their names. And you're having to discuss things that are of a very traumatic and intimate situation, maybe, that's happened, and let me tell you, it's tough. I always say that victims of, particularly of child sexual assault, but victims of any type of crime, they're traumatized once by the crime, and then they're traumatized again when they go into the criminal justice system and have to face a defense attorney who is challenging their credibility, challenging their morals, challenging their memory, challenging, their motives, all sorts of things. And so you end up being called names again and traumatized again. And it is a tough thing to do. And I admire victims who are able to do that. But anyway, that's way far afield from the mediation. We'll talk about that another day. But if you have an opportunity to mediate, I want to encourage you to do that. Mediation is one of the greatest developments, in my opinion, to the legal system. I'm not aware of really any state that doesn't utilize those, and you have a way to know an outcome that you can count on with a settlement, as in the cases of my cases with a personal injury. You don't have to worry about an appellate court turning something back. You don't have to worry about a jury just not seeing it your way, or a jury not seeing it your way for the amount that you think you were harmed. Any number of things that could happen, just sometimes delays. The case that we mediated yesterday, if that case, because there are a number of other plaintiffs, and had that case not settled, we likely would not, and again, this is 2025, but you're dealing with you're dealing with probably 100 plaintiffs, and the judge had made the decision that they were going to try the cases one at a time. So if that was going to happen, that case may not even get set until 2029, 2030. And that is a tough thing to have to wait for your case to come to trial that many years later and have this hanging over you that long. Again, it's long for attorneys, but it's what we do, so we don't consider it to be hanging over our heads. But when it's your case, it's tough. So I do want to encourage you, if you get a chance, you have a case, get a chance to mediate it, no matter what it is, you go ahead and do that, because I think you'll be happy with the result.